Hello, everyone, and welcome to this second in what we hope will be an ongoing series of collaborative webinar sessions between AIPPI's Standing Committee on Traditional Knowledge, Genetic Resources and Traditional Cultural Expressions with the Traditional Knowledge Division of WIPO. My name is Daniel Lim. I'm an IP litigation partner at Kirkland & Ellis in London and Vice Chair of the Standing Committee, and I will be acting as your moderator today. Our session today focuses on the protection of genetic resources and is titled Introduction to Intellectual Property and Genetic Resources, Recent Developments at the International Level. Today's session will be followed later in the month on the 29th of June by a second webinar on genetic resources that will involve a more detailed discussion of the practical issues in working with genetic resources and in implementing and complying with international frameworks with perspectives from public body stakeholders in Asia and Latin America. I'd also like to take this opportunity before we start to mention that in parallel to these webinars on genetic resources, the Standing Committee is also running a series of sessions which are focused on the topic of traditional knowledge and traditional cultural expressions. Last month, we had our first joint webinar with WIPO, which dealt with that topic, and that session will also be followed by another next month, which you'll hear more about soon once details are circulated. Before we get into the substantive discussion, on behalf of the Standing Committee, I'd also like to thank the Bureau and our responsible reporter, Ralph Nack, for their continued support, our tireless chairperson, Martin, for all the work he's put into getting the many new activities of the committee up and running, and of course, the Traditional Knowledge Division of WIPO, led by Wend Wendland, and with invaluable contributions from his colleagues, Begonia Vereno, Daphne Zografos-Johnson, and Shaquille Bhatti. Now, I'm going to briefly turn over to Wend and to Ralph, who would each like to wish everyone who's joined the session a very warm welcome and provide some introductory remarks. Over to you, Wend.
Daniel, thank you so much. And to everybody who's joining, good morning, good afternoon, and good evening. I'd like to also greet and acknowledge the presence of Ralph Nack, the AIPPI Second Deputy Reporter General. And Ralph, thank you for your immense support for these events. It's a real delight for WIPO to co-host this webinar on, as Daniel has just mentioned, on the interface between genetic resources and intellectual property. This is the second webinar in this series. And again, I salute the AIPPI and especially Martin Michaus, who's the chair of the AIPPI Standing Committee on IP, and GRs, TCE and TK, and Daniel Lim, who's the vice chair, for coming up with the idea of having these events. And as Daniel has also mentioned, the first one was on traditional cultural expressions on May the 18th. As I said last time, I'm hoping that through these webinars, the AIPPI members will become not only more informed, but also more engaged and more active on these issues, which ask profound questions about the kind of IP system that we want. What should IP protect, why, and for whose benefit? Indeed, a discussion, as we'll be having shortly, of the interface between GRs and IP quickly leads towards fundamental questions about the future of the IP ecosystem. You will be in the excellent hands of my colleague Shaquille Bhatti, a global expert on the subject of today's event. You will find his presentation extremely rich in content and thought-provoking. He will first give you some historical or history and context, and then share with you what is currently happening at WIPO, in particular the process in the WIPO IGC, and as importantly, the practical training, mentoring, and matchmaking services that we offer. And we hope that this presentation this afternoon will pave the way very well for your own webinar on this subject in a couple of weeks. Finally, I thank my colleague Begonia Vereno, a senior counselor in the TK division, who has been our principal liaison with the AIPPI in organizing these events. So once again, and finally, it's a great pleasure for WIPO to be working with AIPPI on this, and I wish you all an interesting presentation. Daniel, back to you.
Thanks very much, Wend. I think, Ralph, if you have any sort of other opening words.
Well, it's just to thank you all, to thank you to the leadership of this really great standing committee, and really very, very warm and heartfelt thank to WIPO for this tremendous support went to you, all your team. This is a very important topic for AIPPI. You may have thought in the past, AIPPI is all about patents, trademarks, designs. Yeah, this might have been true in the past, but AIPPI has a very important project. And this webinar and the previous webinar are kicking off this very important project. What are we aiming for? We are not aiming for a new international treaty. No, that's not what we want to have. And because we are realistic, there will be no such international treaty. However, what we think is achievable is creating rules, creating a, if you want, a toolbox for the countries who can eventually monetize the wealth which they have, genetic resources, traditional knowledge, and use it as an intellectual property right. And in order to do that, we need to understand what kind of regimes are already in existence, how they work, maybe how they don't work, and how they can improve and hopefully also harmonized on a country by country level, not by an international treaty, but rather by a set of well-functioning rules which we can recommend to the various countries, and hopefully together with WIPO also help these countries to implement them and put them into practice. So that's the long-term goal of AIPPI. And again, we are extremely grateful for the leadership of the standing committee and the leadership of WIPO to make that hopefully happen. Thank you. Back to you.
Thank you so much, Wend and Ralph, for those very warm words of welcome. We're looking forward to continued close collaboration on further sessions and beyond. So turning to the topic of hand, I'm just going to say a couple of words to set the scene a little bit before introducing Shaquille and touching on some housekeeping before turning over the stage to him. So many of you listening in on the webinar will likely have an appreciation for the importance that genetic resources and biodiversity has played and will continue to play across a diverse range of industries as a source of information and inspiration for example, lead compound protein generation in biopharma, trait generation in plant biotech, and molecular tools in basic biology and molecular biochemistry, to name just a few uses. In this backdrop, the value of genetic information seems only to continue to rise, even as the costs of sequencing of genetic information continue to fall. In other words, access to genetic information has never been broader or more accessible, and its value at the same time and the range of practical uses to which it's been put has never been higher or wider. In this context, it's never been more important that the issues raised by the exploitation of genetic resources and traditional knowledge and their intersection with IP are openly raised and discussed amongst the IP and broader international community. And as such, I have the very great pleasure in today moderating this webinar on this important topic and introducing a true expert in the field of Dr. Shaquille Bhatti. Shaquille is the WIPO officer working on all substantive matters related to IP and genetic resources at WIPO. He joined WIPO in 1996 and was instrumental in establishing the Global IP Issues Program, which initiated WIPO's work on IP and genetic resources, biodiversity, and biotechnology. And then from 2004, he was head of the Genetic Resources, Biotechnology, and Associated Traditional Knowledge section of WIPO, and represented them in discussions with other international organizations working on access and benefit sharing schemes for genetic resources, including negotiations for the Nagoya Protocol, the Bonn Guidelines, and the FAO International Treaty on Plant Genetic Resources for Food and Agriculture. Before that, Shaquille obtained his doctorate from Duke University in the US, focusing on the scope of patentable subject matter under TRIPS in relation to biotechnological inventions and genetic resources. And he's currently doing another second PhD in life sciences law, if that wasn't enough. He's also taught international patent and biotechnology law policy at multiple universities across the world, including Austria, Belgium, India, Japan, and Sweden. and has been involved in numerous expert groups on a wide range of topics. It's quite a mouthful, quite a CV. I think it's absolutely safe to say we are in extremely safe and experienced hands with Shakil, and could not wish for a better qualified person to be taking us on this introduction to genetic resources and the intersection with IP today. In terms of the way this morning or evening or afternoon, wherever you are in the world, the session today is going to run, Shakil's going to give a presentation for about 25 minutes, following which we'll have about 15 minutes or so of Q&A, whatever takes us to the end of the hour. If we can just have, there's a housekeeping slide which Michelle will bring up momentarily. I think it might be the next one. Here it is. So as we can see here, in terms of questions you may want to put to myself or Shakil, please use the Q&A box, which is available just under the Zoom panel window in the panel of options there. You can post your questions there. And if you have any technical issues, please get in touch via the chat function. We've got Michelle from the AIPPI events team on hand to assist with that. Shakil and I will do our best in the time we have available to get through as many questions as possible. I'm sure there will be many. And I should also mention that after the session, a recording will be available via the AIPPI YouTube channel. And Shakil's slides, if you'd like a copy of them, are available on request through the AIPPI events team. So with that introduction and the housekeeping taken care of, Shakil, the stage is yours.
Yes, thank you very much, Vint and Ralph and Daniel. And it's a real pleasure for me to join you this afternoon at this AIPPI WIPO webinar and to brief you on intellectual property and genetic resources as they pertain to the most recent international developments. And I've prepared a small set of PowerPoint slides to give you a very introductory overview, and I understand there are some outstanding experts in this webinar, and also some who are newer to this particular area of intellectual property. So this will be introductory, and I would like to brief you in 7 parts. First, as Vint had mentioned, starting from just a historical perspective of how this field of intellectual property has evolved. Secondly, I'll just give a quick panorama snapshot of the main international legal instruments and agreements and processes that are shaping this area. And then thirdly, I'd like to give you a quick impression of the interfaces that have really evolved among and between those instruments and processes. And that is at 3 levels. First are statutory interfaces, second, technical interfaces, and third, rights management interfaces between intellectual property and genetic resources. And then in conclusion, just a few words on currently emerging issues in this area, mostly driven by new technologies such as genome sequencing that Daniel mentioned. And in conclusion, I'd like to tell you about WIPO's work in this area, particularly that of the TK division, in which we'd be very happy to have your engagement as well, as Vint had already mentioned. So let me just begin right away with the historical part, and let me begin right at the, so to speak, at the origins of international industrial property law. Here, and that is at the Paris Convention, of course. And here you see the original text with the signatures and seals. And it's quite interesting to see that in the 19th century already, in 1883, when the Paris Convention was being adopted, that the union members already at that point in time adopted the following language when they were defining the scope of industrial property protection in Article 1. And Article 1, paragraph 3 states that industrial property shall apply not only to industry and commerce proper, but likewise to the agricultural and extractive industries and and to all natural products, for example, wine, grain, tobacco leaf, fruit, cattle, beer, flowers, and flour. And from that point of view, 8 out of those 10 examples relate to either genetic or biological resources, or their parts and components, or derivatives or products thereof. And of course, that doesn't mean that this provision states that all industrial property titles, such as patents, should apply to all products in this list, but rather, according to the commentary of that time, the purpose of this provision, I quote, is to avoid excluding from the protection of industrial property activities and products which would otherwise run the risk of not being assimilated to those of industry proper, end quote. So there is therefore obviously no intent or obligation for Paris members to grant patents for fruit or cattle or wine as such, but it's rather a reflection of the union members' intent to ensure that genetic and biological resources inter alia are an integral part of industrial property protection and its scope. And since then, since those early days, WIPO has done quite a bit of work on this area. After 1883 and the Paris Convention in 1977, the Budapest Treaty was adopted, which you see here. Then in 1984 to 88, the WIPO Committee of Experts on Biotechnological Inventions and Industrial Property really focused on this area for the first time in 1998. That is the Biotech Working Group. Then in 1998, we initiated this program 11 with a subprogram on biological diversity and biotechnology. And you will see here for the first time a kind of convergence that we'll come back to. Then in 1999, the WIPO Working Group on Biotechnology met. And at the same time, there was a series of fact-finding missions that also covered genetic resources that are being utilized by traditional knowledge and traditional knowledge holders. And at the same time, in 1999, the diplomatic conference for the adoption of the patent law treaty at the very late stage considered a proposal for disclosure requirements for genetic and biological resources in patent applications to be included in that draft treaty. Eventually, that was decided not to be included. But then in the following year, the WIPO General Assembly decided to create the WIPO Intergovernmental Committee on Intellectual Property and Genetic Resources and Traditional Knowledge and Folklore that Wendt had already referred to. And that committee has since then been working extensively on this particular area, inter alia, and has, and that work is very much ongoing, and we'll hear more about it in a moment. So that has really been a thread in WIPO's engagement with this area. Additionally, the WIPO program, the TK division, also does a lot of capacity building work, awareness raising work that now also focuses on services and training and mentoring and matchmaking related to IP rights management in this area. And with that, that sort of intellectual property side of the historical trajectory, I'd like to add a parallel sort of universe for a while, that in which in environmental law, where UNEP at the time was initiating work to govern and regulate access to genetic resources. And here, historically speaking, genetic resources, of course, under the doctrine of the common heritage of mankind, were governed by the fundamental principle that genetic resources are a part of the common heritage, and that access and utilization of those resources should be free, as in unrestrained, unrestricted. And this, by the way, is reflected in the first legal instrument that we have, strictly speaking, in genetic resource law, that is from 1983, the FAO International Undertaking on Plant Genetic Resources, non-binding instrument, which states in its first preambular paragraph that plant genetic resources are a heritage of mankind to be preserved and to be freely available for use, for the benefit and of present and future generations. So this very much is a spirit which still pertains in the food and agriculture area, but that was previously there universally for all types of genetic resources. Now, in the mid-1980s, UNEP, United Nations Environment Programme, began work in a working group, which over time began working on an international instrument, and that led eventually to the Nairobi conference, which adopted the Convention on Biological Diversity. And you might recall from the Rio summit that this was one of the 3 Rio conventions that were promulgated at that time. Now, the CBD fundamentally changed the principle of the common heritage of mankind, particularly through Article 15, in which the convention recognizes the sovereign rights of states over their natural resources, and that the authority to determine access to genetic resources rests with national governments and is subject to national legislation. So you see this fundamental shift. Now, since then, the work in the CBD has been ongoing, and in parallel, the agricultural track that came from the international undertaking was then updated to bring that international undertaking to harmony with the CBD. And this led in 2001, after 7 years of negotiations, to the adoption of the International Treaty on Plant Genetic Resources for Food and Agriculture. And that is the first sectorial instrument on access to genetic resources and benefit sharing. The next year, the CBD adopted the Bonn Guidelines, a soft law instrument again. And the first wave of national access, first generation of national access legislation had already been promulgated by CBD contracting parties. And it was very clear that those kinds of restrictive access laws that they had enacted were not facilitating access and were not facilitating innovation, and therefore not the creation of benefits. So there was a consensus reached eventually at the World Summit on Sustainable Development in 2002 that it was necessary to have a protocol or a supplementary instrument on the ABS, access and benefit sharing objective of the convention, and that instrument would have to incorporate also compliance measures and user country measures so that provider countries could enact less restrictive access legislation and still be confident that benefits would be shared. And this led, again, over about 8 years to the adoption of the Nagoya Protocol, which also at the CBD Conference of the Parties in Nagoya, the COP also adopted an entire international regime on access and benefit sharing, of which the convention, the Bonn Guidelines, and the protocol, as well as the international treaty, are the core pillars. Currently also, there's the PIP framework in WHO, which regulates access and benefit sharing for pandemic influenza strains, seasonal strains, and there is the UNCLOS negotiations on marine genetic resources in areas beyond national jurisdiction. This, in a snapshot, is the trajectory that eventually converged with intellectual property, and that led to a number of these 3 sets of interfaces that I'd like to brief you on. Before looking at those, just very briefly on the core components of the international regime of ABS as adopted in Nagoya. The decision there states the core elements are the 4 that I mentioned before: Convention, the Bonn Guidelines, the Nagoya Protocol, and special agreements under Article 4 of the protocol, which are recognized to be part of the regime, but only the FAO International Treaty is expressly mentioned. But one could assume that the PIP framework in WHO is equally recognized. Then Going briefly through the key provisions of the convention and the protocol that are important to understand the intellectual property interfaces. Just to say, there are three objectives of the convention, as most of you may be familiar with. The third one is the most pertinent one. It relates to the fair and equitable sharing of benefits arising out of the utilization of genetic resources. And that objective is given effect in Article 15 to 18 of the convention, where Article 15, as I mentioned earlier, recognizes sovereign rights of states over their resources. And the same article in para 4 makes that access subject to mutually agreed terms for access, and para 5 to prior informed consent to be granted by the party providing. Now, going directly from the convention, those core provisions in the convention were over time, until the early 2000s, sort of implemented, but also there was clear experience that the implementation was not leading to the desired outcomes, meaning there was a clamping down effect on access, on innovation, and on benefits generated. So consensus was reached that the Nagoya Protocol, what became the Nagoya Protocol, a protocol was needed. And this has 4 core elements: access, benefit sharing, compliance, and the mutatis mutandis coverage of traditional knowledge. The aims of the protocol are to create greater legal certainty for users and providers of genetic resources, and by establishing more predictable conditions of access, and by helping to ensure benefits, in particular where resources leave the country that's providing those resources. The last thing about the Nagoya Protocol I'd like to say is that the annex contains multiple references directly to intellectual property. The annex contains a list of monetary and non-monetary benefits that are to be shared. And both of them, both lists contain, as you see here, an item on joint ownership of relevant intellectual property rights. Now, whether that might be practical and effective or efficient is another question, but it just shows that this engagement, this convergence had been taking place over those years and had then been reflected in the instruments. And the same goes for the FAO International Treaty as well, which has multiple intellectual property provisions. Now, going directly to those interfaces that have evolved, I'd just like to briefly highlight 2, that is the statutory interfaces, the 3 actually, the technical measures and interfaces, and then the rights management interfaces. So statutorily, here you see all the countries that have so far acceded to or ratified the Nagoya Protocol. It's 130 at the moment. And all of these countries, of course, undertake by the act of accession or ratification to enact adequate access and benefit sharing legislation. So on a statutory level, you can see that there's a rapid emergence of access and benefit sharing laws that will regulate purely the access to genetic resources. And in the discussions and the negotiations leading up to the protocol, a lot of discussion was held on intellectual property, in particular patents, and the grant of patents being a so-called checkpoint for the downstream monitoring of compliance that was a big topic during these negotiations. Eventually, those kinds of provisions were not incorporated into the protocol. Nevertheless, a number of these national access legislations do have those kinds of provisions incorporated. And that is the second kind of statutory interface I'd like to flag, and that's now from the intellectual property side, where while this was happening on the environmental and agricultural law side, on intellectual property, also some countries had been introducing such disclosure requirements, specific ones for genetic resources. WIPO has done a lot of work on this, in particular in the Intergovernmental Committee, where there's a draft text called the composite text, and there is the chair's text that sets out a specific set of provisions relating to that. We've also prepared a set of key questions for policymakers and practitioners that relate to those disclosure requirements if and when you come across them as practitioners. There's also information resources that we maintain, for example, an overview of all the various national laws, both patent laws, intellectual property laws, as well as access laws that contain such provisions when you're filing patent applications. This table is regularly updated. The latest one is just now from June of this year. So it's a reference simply for you when useful. The second set of interfaces are actually complementary and in fact might equally or more effectively address a number of the concerns that were expressed about the misappropriation of genetic resources and especially the recognition of genetic resources as prior art. And here, technical proposals like the creation of improved prior art databases and search systems are very effective, have also already been implemented in a number of different countries and different patent offices. And they are equally under discussion. There is some work that has already been done in this area and further work that's important to be also taken forward. In addition to the aspect of, let's say, the information systems as such, there's also the aspect, of course, of the information itself. And especially today, as we are going through this tsunami of sequence data that are emerging from very high throughput and low cost genomic sequencing techniques and other molecular characterization techniques for genetic resources, it's important to standardize these data. And WIPO has developed a very extensive and effective standard, ST26, which is just superseding ST25, on the presentation of nucleotide and amino acid sequences and sequence listings in patent applications, now also in machine-readable format in XML. And that certainly already in itself is a huge improvement for searchability and accessibility, especially with the big data sets that everyone is now dealing with. And with that, let me come, this already directly connects with the third set of interface, and that is the set of rights management issues and practices that are important and becoming increasingly important when it comes to IP and genetic resources. We have done a lot of work on contractual tools in the form of GR licenses, access and benefit sharing contracts, material transfer agreements, material access agreements, and so on and so forth, which contain intellectual property clauses. And I'll come back to that in a moment, and would like to say that an additional layer that directly relates to that is how users of intellectual property and genetic resources actually determine freedom to operate within the multiple and complex encumbrances that can now at times attach to a particular set of know-how, data, or invention that utilizes genetic material. More effective trade secret protection, which is quite important in the area of genetic resources. A lot of misappropriation occurs simply because plant breeders, for example, utilize and protect elite breeding lines in their breeding programs as trade secrets. And the genetic resource itself constitutes the trade secret as well as the characterization data. So that's important to have effective protection. And fourth, prior user rights recognition closely related to that is important. And finally, licensing once an invention reaches commercialization stage. And there is a big part, this is on the commercial side, and there's a big part in genetic resources where public research, public agricultural research, or public medical research are undertaken in order to disclose the resulting research results. And for that, to create legal certainty in technical public disclosure, especially when it comes, for example, to uploading sequence data to some of the large sequence repositories. To create legal certainty, it's important that there is certainty on the date of disclosure, the scope of disclosure, and the nature of disclosure, but in terms of disclosing the sequence, the function of the biological function of the sequence, and the technical use. Simply to have legal certainty, both for anybody wishing to innovate with that disclosed sequence, and not at a later stage to be facing disputes or litigation, and secondly, also for those disclosing. So with this in mind, and based on the continuous capacity building and training programs, we have been developing a service tile, which you see here, that pertains to IP rights management for genetic resources and data, and that contains a lot of information material. Before just coming in conclusion to WIPO's work, this has already been mentioned by Daniel. You're all familiar with the exponentially growing rate of genomic sequencing and the resulting data sets. Those create completely new innovation pathways that are much more data driven. Those in turn change the use and again, the management and the exercise of IP rights based on new, more data intensive innovation patterns. And that in turn changes also the needs for intellectual property protection and the needs for IP management tools. So in recognition of this, WIPO recently, in the context of the COVID-based pause of the WIPO Intergovernmental Committee process, held a seminar on IP and genetic resources. This seminar had also a panel that addressed precisely these new and emerging issues and technologies. It had three objectives. One is to create a space simply for the sharing of empirical information, exchanging of perspectives and ideas. It was not, of course, part of the WIPO IGC process, intergovernmental process as such. Nevertheless, it addressed a range of important issues that are being negotiated in the IGC and gave useful historical accounts into the evolution of this set of questions. Also, it informed about those new data mining techniques that can increasingly also play a role in the IP context. And with that, let me come to the last part very briefly on WIPO's work. Here, there is, for those who might not have focused on this particular area of intellectual property before, very introductory material like this brief in a series of traditional knowledge division briefs. This is brief number 10 on IP and genetic resources. It has recently been updated to also reflect those new issues, the new technologies, and the resulting IP issues. And it's just a few pages long and gives an overview. And let me mention, increasingly, what's important is that no longer just the industrial property rights are important, but of course, increasingly, also copyright comes into the picture and technological protection measures, including next generation technological protection measures that are being applied to data. So it covers all those areas. Besides that kind of information providing that the TK division does, it also serves as a secretariat of the Intergovernmental Committee. This committee has had now more than 40 sessions, many of which have focused on genetic resources, and that's a important process. And finally, we have this guide on the access contracts, which you see here, and which is based on a database, an online database of such agreements, both real-world agreements and model agreements that are compiled here for you as practitioners. If you ever want to look for clauses that have been used in practice. You will find them here with a customized searchable search engine where you can simply click on the type of provisions you're looking for. And in conclusion, we have important training and mentoring programs. As mentioned, is a distance learning course that has just actually been launched last week on intellectual property and genetic resources in the life sciences. It contains a number of modules and case studies and so on. And we have a program that we run together with the Swedish Patent Office, PRV, on IP and genetic resources in support of innovation. And with that, I'd like to conclude and thank you for your attention. And of course, the most interesting part is now the discussion with Daniel's chairing.
Thank you so much for that, Shakil. Hugely educational. Maybe just to kick things off in terms of the Q&A session, my first question would be, what comes next? You've just explained to us that there are these frameworks in place. There are various stages of implementation, various stages of ratification in different places around the world. So what comes next now, and what's the current priority for the international genetic resources community, if I can sort of put it that way?
Absolutely. Well, thank you, Daniel. Actually, that's a very key question, and this was just a kind of a backward-looking thing. In terms of forward-looking outlook, I would say this just ad hoc. I would say that there's three things that are right now, let's say, at the forefront of the attention of that community. One is implementation of the existing frameworks. So the Nagoya Protocol, 10 years now, is facing a number of key issues in terms of the next phase of implementation. Other sectoral instruments like the international treaty is going through an enhancement process, the PIP framework. So implementation of existing frameworks. Second is new issues which are also emerging in that area, and they correlate very, very closely. In fact, I might here say they actually originate in intellectual property more than in genetic resources, and that is the data. So the question of whether these access and benefit sharing frameworks should also be applied to, for example, sequence data that characterize a particular genetic material is very much in the forefront of attention there. So that's a second set of issues, emerging issues there. And let me say they come really very much out of the regulation of pure intangibles. So this really is something that's actually an IP question. And then thirdly, there is also the what is happening is that these existing frameworks are already transforming IP practice to a certain extent, because as you saw in the Nagoya Protocol, in the Bonn guidelines, there was reference to having IP clauses like joint ownership in ABS agreements. But what we're witnessing more and more now is that we're having actually ABS provisions in IP licenses, for example. So there has really been a transformation in practice here. It's a little bit sectorially specific between the red and the green, but generally speaking, I would say that IP practice is rapidly transforming when it comes specifically to these interfaces. Maybe those three areas.
Yeah, and just sort of jumping off from that last point you were making, Shakil, who's driving the change?
Yes, thank you, Daniel. In fact, I would say that the change is being driven at the policy level by a number of intergovernmental processes. And I here just listed the instruments just for brevity. But then each of those instruments has a series, of course, of intergovernmental multilateral processes. And there are other processes or fora, intergovernmental, that are setting policy even without an instrument, such as the FAO Commission on Genetic Resources for Food and Agriculture, And so policy change is being driven mostly through those processes. And at the same time, changes in practice, in ongoing legal practice in this area are actually simply evolving, I would say. And they're evolving in response to both the changing legal frameworks and policy processes, and they're evolving in response to changing technology very much. So I would say it's those two layers of change and drivers.
That's very interesting. I noticed one of the slides you shared earlier seemed to be a sort of summary table of the sort of current state of implementation of some of the frameworks in individual jurisdictions. And there was one column right on the right-hand side, which was sort of along the lines of the consequences of, failing to comply with disclosure, consent, whatever the relevant requirements was. And I couldn't help but notice, at least for those two countries, it was sort of noticeably blank. Is that kind of a significant gap and issue, generally that there's a lot of discussion around at the moment? And is there, to the extent that you can address this, is there kind of a current best thinking practice, or what's kind of the prevailing view on that front?
This is on the front of
was which slide? Sorry, I'm just having. It was the slide 16 in your presentation.
Mm-hmm. Oh yes.
On the annex disclosure requirements table.
Yes, absolutely, yes. Yes, thank you. So on that side of the interfaces, I would say there's two things. One is that countries often they're in a constant, of course, process of revision of their, let's say, patent legislation, and the same applies for their access legislation. And so in that sense, there is a gradual sort of kind of proliferation of the provisions or of introducing disclosure requirements. And we can see this over time, and the sort of, the curve has increased a little bit. At the same time, there is this multilateral discussion about trying to establish, as you said, best practice or harmonization of some kind to set both minimum but also maximum standards of what such disclosure requirements can actually require. And on that level, there is really no consensus at this stage among the member governments, because some governments simply feel, well, such a requirement, when it is really specific to one type of subject matter, such as genetic or biological resources, are really not in sync with the objectives or the spirit of the patent system. And therefore, there is discussion, extensive discussion, and there are some drafts, including by the chairman of the aforementioned Intergovernmental Committee, which seek to kind of find a common denominator, but there's at present still very diverging views on what such best practice could look like. I'd also like to add, one needs to see these options for ensuring, or let's say preventing, the erroneous granting of patents through disclosure requirements. One needs to see that in conjunction with the possibility of achieving the same objective of preventing the granting of those erroneous patents through improved prior art searches, such as improved prior art search systems and databases. So between those different views, there are still diverging opinions.
Yeah, I mean, I can appreciate it. It's difficult and complex, and there are lots of different interests here. I mean, just maybe to offer an observation from myself, and let me know if you agree this, Shaquille, but I mean, it seems, everyone wants a system that's going to be practical and that facilitates the ability for parties to validly obtain IP in circumstances where they tick all the requirements properly, but at the same time also to reliably and easily commercialize and transfer, license, whatever they need to do with those IP rights. And I can see how, from a certain perspective, unless you've kind of bought into the sort of policy drivers and the very real and very good justifications behind the sort of frameworks we've been discussing, that unless you bring stakeholders along, it could be seen as just another box to tick, another sort of obstacle. So I guess the question is there: how do we bring along the community, the stakeholders, and get buy-in to the practical implementation of additional requirements? How do we present this as a benefit to the system? Mm-hmm. What's the sort of thinking on that?
Yep. Well, I would say that indeed, as you very rightly say, there's a lot of experience that still needs to be gained, and those who have already such requirements have such experience. And one thing that, for example, the WIPO Intergovernmental Committee has been doing or trying to do extensively is to facilitate that exchange of experience and facilitate that information sharing, and consequently also awareness raising and understanding of what the pros and cons of such different solutions can look like, which are by no means mutually exclusive: disclosure requirements or database systems. So I think one thing that really has already brought the discussion, if one looks at it over time, a long way in terms of its maturity and its differentiation and its nuance on a substantive and technical and operational level, is really a continuous process of that kind of information sharing and sharing of experiences. And then secondly also is over time the accumulation and sharing of information on the transaction costs of the different solutions. Because as you rightly said, the transaction costs of any such solution that would effectively prevent the granting of erroneous patents, which surely is not in the interest of the patent system, is still an important factor. And gradually also experiences with that are emerging. And I think that kind of information sharing is an important part, which the committee does. That's what it's there for.
Yeah. No, I think you make an excellent point about the sort of sharing of I guess, sort of best practice and role models and particular practical examples where you see the system really working as it's intended, and the benefits are sort of clear to all of those involved. Actually, that leads very nicely into what was going to be my next question. I mean, are you able to sort of, I know I'm sort of putting you on the spot a bit here, but do you have any particular sort of examples of that nature that you're able to share today? Of success stories, model examples of this really working in practice.
Mm-hmm. This would be success stories and model examples of those two solutions, the disclosure requirements and database systems. Is that specifically?
Yeah, or just just any aspect of implementation under the. Yeah.
Sure. So on this aspect of the preventing the granting of erroneous patents, there are indeed some experiences that have been quite, well explained and described by the institutions or member countries that had taken them, and those are, on the one hand, when it comes to, for example, database systems, there have been a number of approaches that have been developed by at different points in time. There was the traditional knowledge digital library, which was specifically designed for facilitating prior art searches, and that was then made available to patent granting authorities. And also various patent granting authorities have improved their search systems when it comes to searching and discovering prior art. And then on the disclosure side, a number of countries that have enacted them, like, for example, Switzerland has done detailed case studies and reports on their experiences with it. So those, I would say, and also in the context of the Intergovernmental Committee material, there are multiple documents, and I would point to those by Switzerland in particular. India, Japan had submitted very good material, and happy, it's of course all on the website, but we'd also be happy to point those out in detail if it's of interest. Maybe this just briefly on that sort of granting of erroneous patents. I do think there is an additional dimension to this interface, which is actually that of sort of positive innovation, facilitation, and rights management. And in that respect, a few things that are now becoming more and more evident is that in the contractual practices that are being used for structuring, for example, research collaborations based on genetic resources or breeding programs and so on, that there is a increasing kind of merging almost of what was previously a separate field of ABS and a separate practice of IP into almost kind of hybrid kind of arrangements. So, for example, in the context of licensing, ABS provisions or provisions related to the transfer of material and data are actually becoming more and more common. And there are gradually also practices evolving there that one can build on from that's beyond the granting of patents.
Yeah, that's really helpful. Just got an eye on the time, but we're sort of coming up to the end of the hour, but I think there's time for just a couple more quick ones and just dipping into the Q&A box, so to speak. I'm just trying to pass the question. I think that there's one here, which I think is essentially asking about the sort of degree of harmonization or uniformity we're seeing in implementation, to the extent that we're starting to see that. And then a second part, which I think is asking about where the line is drawn in terms of where the access and benefits sharing requirements under the frameworks are enlivened, in terms of, you know, how far, you know, when the information or the exploitation of the resources is sort of gotten to a stage of further development or sort of overlay of additional technical input, at what point does the sort of that evolve beyond the subject matter, which would require, which would, I guess, attract the requirements?
Mm-hmm. Yes, yes.
So there's two questions in there. Sorry.
Right, indeed. Thank you. Maybe, and I also just now actually could open the Q&A box. Perfect. In fact, maybe just in terms of those two questions you mentioned, of course, the second one that you mentioned is exactly the question of derivatives and what occurs with derivatives. At what point, how far are these reached through provisions that will more or less accompany the innovation chain through derivatives? And then that leads to two questions, which is, so first of all, how do we define derivatives in different contexts when looking at different forms of utilization? It's different if we're talking about plant breeding or industrial enzymes. So, and then secondly, is the question of what is within and beyond the scope of application of the Nagoya Protocol in particular. And so breaking it down into those two questions, okay, at present, there has been no litigation or case law yet on these questions. All we can say is that different contracting parties at present are interpreting the Nagoya provisions in accordance with their own practice. And this differs widely. This is something we can also certainly say. There is some interesting material on that, by the way, how derivatives are being handled by different access and benefit sharing legislation, also on the CBD website. And then, so this was the second question on the derivatives. The first one was regarding the
I guess the degree of harmonization or uniformity that you're seeing as implementation progresses.
Yes, thank you indeed. So in essence, there is the Intergovernmental Committee and the so-called COPMOC, the Conference of the Parties of the CBD, acting as the meeting of the parties of the Nagoya Protocol, which is the governing body that governs. I know, it's indeed. That is the body, the intergovernmental body that governs the implementation of that protocol. It is taking stock, it is providing a certain set of guidance in terms of implementation. What one can also say for sure is that certain parts of the protocol, for example, a multilateral mechanism for benefit sharing, are not yet, implementation hasn't even begun. So that is pending. However, what has actually progressed more is the promulgation of national access legislation in implementation of ratification, or the amendment of existing legislation when a country had already been previously party to this.
Okay. So I'm conscious we've just gone over the hour, and we should probably wrap things up there. I know there are other questions which we haven't had a chance to get to, but maybe in the version of the slides which we make available, if that's okay with Shakil, maybe we could consider having a section at the back which perhaps addresses some of those, and in particular provides more information about your excellent new course that's been running. We've got some questions about that and about other resources that are available, which I'm sure Shakil will be more than happy to sort of follow up on and provide more information if people want to reach out. So with that, I think all that's left to say thanks again so much to Shakil for sharing your fantastic insight and expertise with us today. Thanks again to Ralph and Wend and AIPPI and WIPO for the continued support, and for everyone for joining in today and sending in such great questions and being engaged on this important topic. Thank you all. Bye, everyone.